Welcome to the Professional Edge. My name's Todd, tax attorney, CPA, and this session, let's eat. And what do I mean by let's eat? Well, E stands for get your estate plan in place. A stands for a financial plan, and T is for tax planning. So we're going to combine all three of those and put them all together. And the first place to start is let's get your estate plan for the Let's Eat part of the show. So estate planning is basically putting a document in place so there is a plan for the untimely demise of yourself, and that way we get the right property to the right person at the right time. And what that means is a lot of individuals, the husband has managed all the financial affairs in the house, and then when he passes away, yes, unfortunately, guys, we are going to be the first one to pass away. Our life expectancy is less than our surviving spouse. So with that in mind, how do we make sure that our spouse is going to be cared for, taken care of? Well, there's some planning tools that either A, you can have a last will and testament, which if you've been a listener here on the Professional Edge, I'm not a big proponent of, but at least you have your plan of distribution in force and effect as long as it is a valid will. Now, we've seen downloaded documents, internet documents, even documents from friends and family that they've copied and sort of scribbled through and thinking that this is a valid document. Well, you run that risk if that is an invalid last will and testament, that then the probate court would set that aside and say it's not a valid will. And then your estate would be divided according to the law of descent and distribution, which in the great state of Georgia, that basically says your surviving spouse will not inherit the entire estate, even though you have that intention. Basically, what happens is the surviving spouse is going to inherit half right off the top. Then the other half is going to be split between the surviving spouse and the number of children in equal shares. Now that puts into play whether that child is a minor. If so, then it goes basically in trust for that child, and then when the child reaches the age of majority, then it becomes theirs, lock, stock, barrel, and they have no restrictions on that account. So when we eat this week, let's eat. E stands for estate planning. So that's number one on that probate of having a valid will. That's the consequences of not having a valid will. So when we plan our estate, the other part that we might want to consider is putting an invisible blanket over our assets. And what do I mean by that? Well, I'm sure you don't go around with your financial statement on the side of your car like a billboard, or you just hand a business card out and say, here's my net worth, here's what I own, here's who's going to inherit everything when I pass away. Well, that's what you actually do with the last will and testament. You basically display, it is a public display. So you can go down to your local probate court and pull a last will and testament on your neighbor and identify what is going to be in that estate and who's going to actually receive it. So let's put the invisible blanket on our estate plan and basically keep our distribution, our estate private. And with that, you can do that with a revocable living trust. And then you avoid the entire probate court process altogether. Now, I have a debate all the time with lawyers in the state of Georgia and other states that probate is not a big thing in the state of Georgia. Well, if it's not a big thing in the state of Georgia, then why are there such big attorney's fees for probating the estate? So all you would have to do is say, well, if you're recommending a last will and testament, just go ahead and waive any probate fees that you're going to charge my estate for that attorney that you're talking to on drafting your estate plan. And they will look at you like you have seen a ghost. And basically what they're saying is probate's not a big thing in the state of Georgia because they're going to get excessive attorney's fees. We all know attorneys are egregious on their billing, 6 figures to administer some estates that I've seen. And all of that can be avoided by using a revocable living trust. I'm a big proponent of that. And a great place to get some additional information is on our website. That is emcadvisors.com. That is Echo Mary Charlie Advisors.com. And on the right-hand side is Ultimate Estate Plan Guide. It's a red button. Go ahead, click that, and we will send that information out to you. Gives you a better understanding of what a revocable living trust is and how it can help you put that invisible blanket over your estate. Now, we can have the same plan of distribution inside a revocable living trust as we do a last will and testament, so that's not any different. We identify our decision makers, their successor trustees and alternate successor trustees. And then the other consideration on the concept of let's eat, the E is for estate planning, that we also need to take into account who we are leaving behind. And with that in mind, let's say we are the husband in this scenario, and we want to make sure and protect our surviving spouse, but also we want to protect our kids. With that in mind, we know that there is longevity risk. So therefore, the surviving spouse has the tendency to live, 10, 15 years after the husband passes away. And as people get older, they want companionship. And we've seen marriages in the 70s years of age. And therefore, the risk of disinheriting the kids comes into play. As absent as that may seem, we all want to protect our kids. So how do we protect our kids, even though we have this 35, 40-year marriage that we're sitting here listening to the professional edge and looking at each other saying, okay, I don't trust that next person who you may meet after I have passed away. So what do? Well, the only way we can guarantee that our kids are going to receive your inheritance is that when we pass away, we have a testamentary trust that we leave the assets to. And that way the surviving spouse can have access to those funds. They can have the income from those assets. But when the surviving spouse should pass away, then the first spouse who passed away controls the ultimate distribution of the testamentary trust assets. So the surviving spouse, if they get remarried, and let's say they don't have a last will and testament, again, we go back to what happens underneath the law of descent and distribution. Well, it goes half to the surviving spouse, then the other half is divided between the spouse and the kids. So therefore, we potentially disinherit our own kids. So let's avoid that consequence and place these assets on the first passing of the first spouse and have those go into a testamentary trust, allow the surviving spouse to hold those assets, use them, use all the income from it. It doesn't matter. But when the surviving spouse passes away, and they may have remarried, the potential is there because of longevity risk, then the surviving spouse cannot leave these assets to that new husband or new wife and disinherit the kids. So that way we put that in place. And if you want to have a one-on-one consultation to see how this might work for you, and you like this idea and concept of not disinheriting your own kids, give our office a call at 877-654-9798. That number again, 877-654-9798. So the ultimate plan, the Let's Eat, the E standing for estate planning, we want to make sure that our kids are also protected when we should pass away. So let's skip through, and now we're talking about the surviving spouse. We have the surviving spouse, and we want the assets to go to our children. Now, we all know that greater than 1/2 of all marriages are ending in divorce now, and the largest potential creditor you have is an ex-spouse. Again, I'll repeat that. The largest potential creditor you have is your ex-spouse. So when you pass away, what you want to probably consider, or very much put this on your checklist for Let's Eat, the E is for estate planning, is how do I protect my assets that go down to my kids? Now, they may be in a great marriage today, but you see signs, cracks in the pavement, and that may develop into a divorce. So why even take that risk and try and forecast what's going to happen in the future? Why don't you just put that in plan and force and just say, I'm going to leave my assets to my children in trust. So therefore, they have access and control of those assets. But if something should happen to their marriage, or even a bad lawsuit, a bad business dealing, then these assets are protected from the claims of creditors as well. So again, that's a consideration for your estate planning on Let's Eat. That's the concept of this show is Let's Eat. The E stands for estate planning. The A stands for a financial plan, and T stands for a tax plan. So again, to have a one-on-one consultation, we don't charge for that. Give our office a call at 877-654-9798. That number again, 877-654-9798. So what actually is a testamentary trust? Well, we don't fund it today. We fund it when the surviving spouse passes away. Therefore, the assets go in there. And we want to have the right assets to go inside this testamentary trust because we all understand, or at least being a CPA and a tax attorney, I understand that the trust tax rates can be very egregious. Approximately $15,000, we're at the highest marginal personal income tax rate. So the IRS has basically said, we don't want trusts accumulating a bunch of income. We want it distributed out and consumed. So therefore, structuring those investments would be ideal for that child. So therefore, we don't pay excessive taxes. Again, being a tax attorney and a CPA, and then being an advisor, a registered investment advisor working on a fee basis, then we help the clients also structure that. So you can see basically as we transition and we hand these assets off to that next generation or to the surviving spouse. Guys, who's going to protect your spouse when you pass away? Basically, what's the plan in force and effect if she does not understand investments? Well, wouldn't you want to establish a relationship with a professional? Get peace of mind that things are going to be transitioned very easily and your beautiful bride is going to be taken care of. There's an ongoing relationship because we all know it is a tragic event to lose a spouse, and therefore you know they're in good hands. They're going to get professional counsel and advice as they transition. You know the assets that you've accumulated together during this long marriage are going to go in trust for the surviving spouse. There's going to be professional asset management against those investment assets and your estate. And there's probably going to be a transition with regard to real estate and the tax consequences on that. And then you know that your share of your estate is going to go down to your kids. And then you also have the peace of mind underneath this estate plan that your kids are also going to be protected from the claims of creditors. It's simple. You just need to put your estate plan in force and effect today. Doesn't mean that you lose control of your assets. It means that you're planning. So again, when someone says, let's eat, well, we all sort of charge towards the dining room table and let's begin our dinner or lunch or breakfast. So that's the same call that we're saying this week. Let's eat. E stands for estate plan. Let's get that in force and effect. To get started, give our office a call at 877-654-9798. That number again, 877-654-9798. Appreciate you listening to The Professional Edge. My name's Todd, tax attorney, CPA. We have an office in Atlanta, Georgia, and also a satellite in Columbus, Georgia. But if you're listening to this, somebody's sent this out to you and you're listening to the podcast, we are welcoming the Zoom meeting as well. So again, give our office a call at 877-654-9798. That number again, 877-654-9798.
We've all thought about it. Everyone listening will need one. Not having one can cause untold heartache, family conflict escalating to the point of a lawsuit. One simple thing that avoids all that: an effective estate plan. As a practicing tax attorney, Todd with Estate Management Counselors has completed over 1,000 estate plans during his 15 years of professional practice. He can help you implement an effective estate plan, coordinate your financial accounts, and make sure you have named the proper beneficiaries to maximize your tax savings. Call 877-654-9798 today and let tax attorney Todd help you implement an effective estate plan. Call 877-654-9798 today. As a tax attorney CPA for over 15 years, Todd has implemented over 1,000 individual estate plans. He has recently authored an especially helpful guide, How to Unlock the Ultimate Estate Plan. This guide has helped many individuals to understand the benefits of an estate plan and how to avoid unintended disasters. Has made every attempt to write this in plain English. To receive this valuable guide, How to Unlock the Ultimate Estate Plan, call 1-877-654-9798 and request your complimentary copy today, or by emailing your request to info@emcadvisors.net.